Good afternoon, everyone. Thank you all so much for joining us. I just have a quick note for our interpretation. Today, we will have a Spanish interpreter that is happening simultaneously. If you need to access the channel for the Spanish interpretation, please click the globe at the bottom of your Zoom screen and select Listen in Spanish, and that way you will hear the live interpretation of the presentation today. We are using the webinar format of today's presentation, so we will not be able to see or hear any of the attendees, but we are so happy that you all have joined us. We see that the number is increasingly growing. You will be able to submit questions in the Q&A box at the time of questions. And so I would like to pass that to Camila to say it in Spanish. Thank you.
Okay. Good afternoon, everyone. My name is John Althauser. I'm an attorney with Legal Services of Eastern Missouri, and I just wanted to welcome everybody. We're going to be, this presentation is going to cover 4 areas. The first is going to be leases presented by Susan Alverson, and then we're going to do, John Boyer is going to present a section on the types of eviction lawsuits, and Roger Dyer will present a section on the actual court process for eviction lawsuits. And then last, Marissa Cohen will present on fair housing. After each section, we're going to have a question and answer period. You'll have to type your answers into the question Q&A function. And well, I don't know if we may not be able to, we have a lot of participants, may not be able to answer each question individually. But we will try to sort of aggregate the questions into, and I'll sort of moderate the question asking, I guess. Anyway, and then, so this, just a statement for it, this community education program is brought to you in part through a statewide grant from Housing and Urban Development, or HUD, to prevent evictions in Missouri. The work that provided the basis for this publication was supported by funding under an award with the U.S. Department of Housing and Urban Development. The substance and findings of the work are dedicated to the public. The author and publisher are solely responsible for the accuracy of the statements and interpretations contained in this publication. Such interpretations do not necessarily reflect the views of the government. All right. And then our first presenter is Susan Alverson. She's the managing attorney of the housing program with Legal Services of Eastern Missouri, and she will be presenting on leases. Thank you.
Hi, everybody. Glad that you are here with us today to learn about your rights. Basically, the best way to prevent an eviction is to know what your rights are and to understand what the law is. One of the crucial ways of understanding your rights as a tenant is to understand what is a lease. As we all know, a lease is an agreement. It's a contract. It can be oral, shaking the hands of the landlord. You get the key, you move in. Or it can be a written contract. It's real important if it is a written contract for you to review the terms of that lease contract. The other important thing about what a lease is that it's a conveyance of the right to possess the dwelling. So the landlord may own the property or may be the property manager for the owner. But once you enter into that lease contract, the person who has the right to possess that dwelling is the tenant. And from that stems the tenant's rights. The most important thing is that the landlord does not have the right to evict that tenant without legally doing it. And that means going through the court process. So if you're a tenant and your landlord says, I'm coming Friday to evict you, you can know that's illegal. In some areas, that's even a crime. In the city of St. Louis, it's a crime for a landlord to illegally evict. The tenant has a right to bring a civil action against the landlord that actually changes the locks, disconnects the utilities, etc. So what are the rights of the landlord and the rights of the tenant? Well, the tenant and the landlord, both of them are obligated to comply with the terms of the lease. The landlord's main obligation is to provide a habitable dwelling. I will tell you that for lots of our clients, one of the biggest reasons they stop paying their rent is because the landlord's not fixing up the place. That is a defense, but one needs to be very intelligent about how to go about an issue where there needs to be repairs. Next slide, please. So the thing that a tenant really needs to do is to remember this is a business relationship. The second thing is that not everybody's going to be able to get a lawyer to help them out. So you really need to be your own best advocate. How do you do that? Well, you make sure that you protect yourself. It's like insurance. So what do? You make sure you have copies of all your important documentation. And what do we mean by that? Well, if there is a written lease contract, make sure you have a copy of that written lease contract. If you're paying your rent, make sure that you keep proof of that rent payment. That is very important. The most common eviction action in the state of Missouri is an action called a rent possession lawsuit. That's where the landlord is claiming that the tenant hasn't paid their rent, and because they haven't paid their rent, the landlord wants to evict them. So the whole issue of whether or not you've paid your rent, you need to make sure you always have proof of that. Now, the best proof of that is to have a written and signed and dated rent receipt. But at least don't pay in cash unless simultaneously you get a rent receipt. Most people, most of our clients pay with money order. But the money order stub itself isn't proof that the money was received. It's just proof that you purchased a money order. So again, the safest thing is to make sure that you get a simultaneous rent receipt dated and signed by your landlord. Whatever is your proof of the payment of your rent, be sure that you keep it. That's very important to make sure that if the landlord does claim you haven't paid, you've got your proof. Maybe you've sent notices to your landlord. Maybe the landlord has sent notices to you. Be sure you keep those things also in that a very important folder. Copy of the lease, proof of rent payment, any and all notices between you and your landlord. Next screen, please. So as I said before, one of the biggest reasons for why a tenant is deciding not to pay their rent is because there are bad conditions in the unit, and these have to be pretty bad, not just because you don't like the color of the bathroom wall, but pretty bad conditions. The tenant needs to make sure that, again, they're protecting themselves. So you want to notify the landlord. And it can't just be, oh, he knows about it. You know what? Make sure it is in writing. I used to tell my clients to write a letter. Nowadays, we have two other very quick ways of writing and notifying somebody, and that is by email and by text messaging. Just make sure it's a written notification. Dear Mr. Landlord, as you know, my furnace has been broken for several days. It must be fixed. Another thing that I would advise tenants to do is to make sure they document those bad conditions, because the fact of the bad condition could be a dispute. First, the landlord could say, I didn't know, there was a rat infestation. And you document it. Now you've got photographs. As we all know of the old adage, a picture speaks 1,000 words. So if there's something wrong, like the ceiling has crashed in and rain is running in to the living room, take photographs, take videos. Thirdly, verify the bad conditions. In a lot of places in the state of Missouri, there's a municipality that has a building and health department. Call them up, have them come inspect. Now you have verification. Call up a furnace repair guy, call in the electric gas company if there are things wrong with the gas and the electric. You have verification. Now you don't absolutely need to have the verification, but all of this is being done. So if ultimately you're not paying the rent and your landlord sues you, you now have proof of why you didn't pay. And it's not a big dispute. You've got proof. You notified, you documented the problems, they know about it, and you verified it. Next slide, please. So what you also have is the right to repair and deduct. Now, again, you want to have proof of those repairs. The proof of the bad conditions. And if you choose to go ahead and repair, the landlord's just not fixing the furnace, and you can't do without that furnace, and you hire a company to come in and fix, make sure you have proof. You had notified him of the problem and proof of the repair, the bill. Send that again, written notification to your landlord. You didn't fix this, so I had to spend $200 to fix the furnace. I am now going to deduct this from my rent. Again, this is all done for your protection. So if the landlord does sue you for that rent you didn't pay, you now have a complete defense. You always have to be thinking about what is my documentation? What is my evidence? Next slide, please. Well, if you do choose to do the repair and deduct, in the state of Missouri, it can't be a massive repair. It's going to be $300 or less, or 1/2 of your monthly rent, whichever is greater. So if your rent is $1,000 a month, up to $500, you can repair and deduct. Make sure you have proof, notification, proof of the repairs. Next slide, please. And it is going to be a defense in court if the landlord sues you that they didn't make those necessary repairs to comply with the local building codes for health and building safety. It is a legal defense in court to non-payment of rent. But what is very important here is, again, that you've got your proof. Next slide, please. So if there's a situation in which you say, I am not going to pay my rent because he's just refusing to make any of these necessary repairs, put the money aside. In many jurisdictions throughout the state of Missouri, A landlord can claim that the tenant should have put that money aside, put it aside, because if you're going to have a trial, the judge may ask you if you put the money aside or not. You're going to want to need to have that money in case the judge rules against you, so you can pay the rent and stay. Don't spend it. It's very tempting to spend it, but don't spend it. Again, notification is very important, that you're withholding the rent because the landlord won't repair. And what are those necessary repairs? But again, please note, when you choose to withhold your rent, that is the time at which your landlord is probably going to file that rent eviction lawsuit against you. So make sure again that you have receipt for any repairs that you've made, are proof of the notification to your landlord regarding the bad conditions and proof of those bad conditions. Next slide, please. So right now, we're available, I do believe, to do questions and answers on this.
Yes, I've been monitoring so people have put questions in the Q&A window, and I'll just there's a few of them here. One question is does the landlord have the right to evict or increase the rent before it expires? I'm assuming before the lease expires. So can a landlord?
Very good question. A very good question. So that's why I say, review the terms of your rent. No, your landlord cannot increase your rent if you're in the middle of the lease term, and if the rent is, say, $500 a month. They cannot lawfully increase it. Now, what if the landlord says, guess what? It's going up to $600, and you go ahead and pay that extra amount? That could mean that you're agreeing to it. So don't do so. At the end of a lease, however, the lease term, and it's usually a year, the landlord can say, if you want to renew your lease, now it's going to be $600. So, but not in the middle of the lease term, unless you agree to it.
And if it's a month to month, it could be just at the end of the month too, I guess, right?
So what John is talking about is a type of lease that where there is an oral month-to-month lease. So if you have a written lease, it's usually for a term of a year. If you have an oral month-to-month lease, your landlord can change the terms of the lease upon written notification and at least 30 days written notice that the landlord is going to be increasing your rent. If you don't pay that extra amount, the landlord could claim you still owe it. And if you do pay it, now you have agreed to the increased rent terms.
We're getting some more questions, but I know we're going to start the next one too, but I'm going to try to get a few more, and then I will try to answer them individually in the chat function, but I'll try. There's some questions about the conditions. How long do they have to be in existence? And if you withhold the rent and document everything, can you still be evicted?
Well, there isn't a particular period of time. It has to do with the dangerous extent, the nature of the bad condition. If the roof, for instance, in the house you're renting is so bad that literally it collapses in and the ceiling collapses in, there's no real period of time you have to wait at all. So there's something in law called the reasonable person standard. It's sort of like what is within reason. So if it's in the middle of January, it's below freezing, your furnace isn't working, and your landlord hasn't fixed it in a week, that's probably enough time. And can you still be evicted? Again, a legal eviction requires a court order. Is it possible that the landlord hasn't fixed the furnace? You spend money to fix the furnace, you deduct it from the rent, landlord sues you for it, and a judge actually decides that you owe that money. Look, anything is possible. But if you don't follow protecting yourself and setting it up so that you have a chance of winning, you're not going to. But of course, folks have definitely won. What's important, and later on in this section, is that one of our presenters will talk to you about how you have to plead these defenses. What that means is if your landlord sues you, you have to write out, well, I did not pay because I had to fix the furnace and I spent the money and I notified them. You write it out, you file it with the court. Now you've presented your defense and you have a much better chance of winning if you do the things that I have suggested. Notification, documentation, that's important.
Thank you, Susan. I think there are a lot of questions in the Q&A. I will say that a lot of them are more specific questions that we can't really answer during this presentation. I will try to answer some more of them during the next presentation. And our next presentation is going to be done by John Boyer, who is a staff attorney in the Joplin office of Legal Aid of Western Missouri, or LawMo, and he's going to be presenting on the types of eviction lawsuits.
Hello, everybody. Thank you for joining us. Next slide, please. So, as was kind of stated a little bit by Susan, there are two most common types of lawsuits when it comes to evicting someone. There is a written possession, which Susan talked about briefly before, and an unlawful detainer. As Susan stated in her presentation, a self-help eviction, such as a lockout or termination of utilities, is illegal, and in some jurisdictions can be criminally prosecuted, as Susan stated. Next slide, please. So the first type of eviction proceeding is a written possession. It's pretty self-explanatory. In this type of lawsuit, your landlord is claiming that you owe rent, and their goal is to typically get you evicted, get a court order to evict you from the premises. Next slide, please. There are several defenses to a written possession lawsuit. The first is kind of what Susan was talking about towards the end of her presentation, which is the breach of implied warranty of habitability. As Susan stated, a landlord does have an obligation to try to keep the home in a habitable state for the tenants. And so if they fail to do that, then you can assert one of these defenses whenever you are in court dealing with a written possession action. Like Susan said, these are big, major repair issues, not something small like a cabinet handle broke off, but something more major, such as like a hole in the ceiling, heat not working in the middle of the winter. Another defense available is that your landlord refused the rent, and that's what actually puts you in default. This happens more often than people would think. For some reason, maybe the landlord just wants to rent that home out to a new person, so they refuse the rent. Another defense is that the plaintiff is not the person on the lease as your landlord. This happens a lot of times with apartment complexes. At times, property managers will try to file an action even though they're not the owner of the property and they're not the name on the lease. The fourth one, another defense, is if the landlord is trying to file pro se, but their property is actually owned by a corporation. In the state of Missouri, corporations are not allowed to be represented by pro se litigants. They have to be represented by a lawyer. A quick way to find that out is to call your county assessor or your recorder of deeds office. A lot of times, if you give them the address, they will sometimes give you that information. And I know some counties have an online web address. You could look that up. The fifth defense that we have here is that you do not have a lease or a landlord-tenant relationship with the landlord. I don't find that happens as much, but sometimes it does happen. So if you don't have a lease with that person and there's not a landlord-tenant relationship, they can't file this action against you. Next slide, please. Some other defenses to consider is the plaintiff claims to be a new owner of the property, but hasn't given you proper notice. So if somebody buys out your home and they haven't properly notified you, if you have not paid them rent, then they can't claim that you owe them rent until you're properly notified. But as Susan stated, kind of with the increase in rent, if you do go ahead and start paying that new landlord, then you have accepted them as the new landlord and they can say that you owe rent at that point. You're a tenant living in foreclosed property, but the owner hasn't protected your rights under the Protecting Tenants and Foreclosure Act. This is a situation where you're renting the property, but the landlord for some reason has been foreclosed on. There is very specific things they're supposed to notify you in specific timeframes. You owe no rent and the plaintiff is suing for non-rent claims. This is really important in rent possession. If they're suing you for things like late fees or property damages, they can't claim those they can claim late fees, but they can't claim property damages in a rent possession. And they can't just claim late fees. You have to owe rent and owe late fees before they can file this action against you. The plaintiff, and that kind of goes into the next one, the plaintiff has lumped together rent with non-rent claims like late fees. They have to specifically separate those out, and even now under new guidance from the Missouri Supreme Court, even the judgment has to specifically state what is rent, what is late fees, and what is attorney fees. So they can't just lump all of that together. And then finally, the landlord is suing for property damages. As I stated, property damages are not allowed in a rent possession lawsuit. Next slide, please. The next type of lawsuit is an unlawful detainer lawsuit. This is typically filed when a person is caught up on rent, but as it's stated here, has violated the lease in some way, shape, or form. Your landlord claims you are holding over in possession of the lease dwelling unit after your lease was lawfully terminated. So typically what happens is you are given some sort of violation of lease notice and then a termination of lease notice, and then you're still living in an apartment after whatever date they've given you. The landlord's goal, of course, with this action is to obtain a court order to evict you. Next slide, please. There are some defenses for an unlawful detainer. No written notice of lease termination was given. No notice is needed, though, and this is very crucial to remember. If you are at your lease term, you cannot, they don't have to provide you a notice, but if you're in the middle of a lease term, they do have to provide you with notice. Another one is improper termination of a month-to-month lease. Your landlord in a month-to-month lease, as Susan was talking about, a lot of times these are oral leases, but they sometimes can be in written leases as well. They have to give you a 30-day notice. Now, what a lot of people get confused here is they think as long as it's 30 days, that's okay. It has to be 30 days from the next rental pay period. So if your lease states that your rent is due on the first of the month, and your landlord gives you notice on October 15th, the proper date for them to terminate your lease would be November 30th, because that is 30 days from the next rental period, which is November 1st. And then finally, the landlord files a lawsuit before the demand date to vacate has passed. This is if they've given you a lease, say your termination of lease ended on November 15th, and they try to file the action on November 10th, they can't do that. They have to wait until the termination date on that vacate notice is done. Next slide, please. So there are some special rules when it comes to owning a mobile home. If you own a mobile home and you are leasing the land that the mobile home is on, then a landlord must provide you with a 60-day notice from the date the next rent payment is due. So backing up to the previous example, if your lease says that your rent is due on the first of the month and your landlord gives you a 60-day notice on October 15th, then the proper date would probably be January 1st, because it has to be 60 days from the next rental period. So November 1st would be the next rental period. You'd have 60 days from that. Now, the key is that you have to own the mobile home and you have to be leasing the land. It cannot be a third party or you're renting the mobile home and the land. It has to be you own the mobile home and you are leasing the land. The owner of the real estate may be able to claim the mobile home abandoned if you are evicted and cannot move or sell the home. This is another statute that they have to follow, but keep that in mind that they can eventually claim that you've abandoned the mobile home if you are unable to move it. And like it says at the end, the situation often results in losing a lot of what you have. if you are unable to move the mobile home. Next slide, please. A few other defenses you can assert with an unlawful detainer is, of course, you did not violate the lease. Of course, if the plaintiff is insinuating that you violated the lease, they need to provide evidence. Like Susan said, the best thing for you to do is to be your own best advocate to keep as much evidence as you can that you didn't violate the lease. You violated the lease, but it was a minor violation and not a breach of the material breach of the lease. That a lot of times will just depend on how your lease is worded and how the judge ends up determining it. But you could always make that argument that what happened was a minor issue and not a material breach of the lease. And then your landlord demanded you vacate, but after the alleged date of lease termination, your landlord continued to accept your rent, therefore creating an implied lease and landlord-tenant relationship. So if they continue to accept your rent, after that date they give you in the termination of lease notice, then you could make the argument that they created an implied lease and another landlord-tenant relationship. Next slide, please. Okay, so at this time we have time for questions if there were any.
Okay, I'm trying to answer some as we go in the question and A function. I'll try to look through some of these here to see if we let's see. There's still a lot of questions about the condition issues.
John, I would like to say that I read through some of the questions, and pretty much this law applies to all tenancies, but there are certain additional rights you have if you have federally subsidized housing, like Section 8. And if you're experiencing bad conditions, you really need to contact your caseworker at the housing authority that's administering your Section 8 or the Community Action Corporation that's administering your Section 8 rental assistance. Notifying the landlord of the problems, documenting the problems is important, but you really need to notify the housing authority or the Community Action Corporation. And there was also a question regarding domestic violence, and a landlord cannot lawfully evict you if you are the victim of domestic violence. In the state of Missouri, victims of domestic violence are protected, and you can find that at the statute at 441.920. But absolutely, you want to make sure you assert your right as a victim of domestic violence. Those are some of the questions that I saw that I thought were important to also include answers to.
And there's a lot of questions. I don't know, and to be honest, we're not going to be able to get to all of them. But at the end of the presentation, we're going to give you the contact information for all of the legal services in the state. So I would encourage you to all contact those legal services. A lot of, we can't really answer in this presentation. We just don't have the time. We'll try to answer as many as we can, but I know there's a lot of questions. Anyway, let's see. I guess we do have there were a couple questions about, and I think one of you covered it, about like new property owners buying when a new owner takes over the rental property. Can either John or Susan, can you address that situation?
Yes, when a new owner takes over a property, they do have to give you notice that they are the new owner. They have to provide you some sort of written document stating that we are the new owners, and kind of explaining what procedures they're going to use. Now, if you're in the middle of the lease, typically that lease will continue if you're in the middle of the lease term, but they do have to provide you notice. Now, if you start paying rent to that new property owner and they have not given you notice that they are the new owner, then you have consented to and acknowledged that they're the new owner. But if you have not started paying them rent and they claim that you owe rent, you can make the argument in court stating that they never properly notified you of the new ownership, and that's why you haven't paid rent, and therefore that is a potential defense for you.
All right. Thank you, John. I think it's time to move on to Roger Dyer's presentation, who is the Senior Basic Needs Unit Attorney for Mid-Missouri Legal Services, and he is going to describe the eviction court process.
Thank you, John, and thanks again to everybody who's joined us today. As John mentioned today, I'm going to talk about the eviction court process in Missouri. So if a landlord files an eviction case against the tenant, first off, the tenant will know if their landlord has filed that eviction case because they're going to receive a summons ordering them to appear to court. And a summons is just a court form that notifies people when they've been sued. The summons includes several pieces of information. It'll include the names of the parties. If the landlord has an attorney, it'll include the attorney's name. It'll include the case number, and it'll include the date, time, and place that the tenant needs to appear at court. And this first court appearance is also known as the return date. So in Missouri, a summons can be served on a tenant in one of two ways. The first is through a process called service by posting. That's when the summons is posted on the front door of the tenant's dwelling and also mailed to them. The second way a tenant can be served is through a process called personal service. That's when the summons is hand delivered to the tenant or a member of the tenant's household. Now, in Missouri, a summons can only be served by either the sheriff or a special process server. And a special process server is just an individual who's been appointed by the court to serve the summons in that particular case. Next slide, please. So now I'm going to talk about how a tenant will assert a defense or a counterclaim in the event that they want to do that. So if a tenant is served with a summons, they have a right to assert a defense. For example, if a tenant wants to assert that they do not owe the landlord the rent that they're requesting because the landlord has violated the implied warranty of habitability, this is when they would want to do that. And so the tenant needs to put those defenses in writing. The tenant needs to file those defenses with the court. And I would add that those really need to be filed on or before the return date. It is possible to file those if the tenant misses that deadline, but there are additional steps involved with that that involve requesting permission from the court to file it late. And the court doesn't necessarily have to grant that. So as much as possible, the tenant needs to try to file these on or before the return date. And a copy of the defenses needs to be provided to the landlord. Now, the tenant should also bring all of their evidence supporting their defense to court for their trial date. I will note that the return date normally is not the trial date. Normally, the trial date, at least in my experience, is 1 to 2 weeks after the return date. But of course, when that trial date comes, the tenant needs to bring all of their evidence supporting that defense. Now, in rent and possession cases, tenants can file a counterclaim. And a counterclaim is just a claim brought by the tenant against the landlord, alleging that the landlord owes the tenant money, usually because the landlord has violated the lease agreement. Just like defenses, the counterclaims need to be filed in writing with the court on or before the return date, and a copy needs to be provided to the landlord. And I will note that while counterclaims are permitted in rent and possession cases, they are not allowed in unlawful detainer lawsuits. Next slide, please. All right, so now I'm going to discuss some of the judgments that courts can enter against tenants in eviction cases. And the first type of judgment is called a default judgment. Now, default judgment is the type of judgment that a court can enter against the tenant anytime they fail to appear for any of their court dates. If the tenant fails to appear for that return date on the summons, the judge can enter a default judgment against them. They can also enter a default judgment if the tenant fails to appear for any subsequent court dates. Now, the judge can enter a default judgment for the amount of money that the landlord is requesting. So that can include unpaid rent, fees, cost, really whatever the landlord's alleging that the tenant owes. The default judgment can also be for possession of the property, meaning that the tenant can be evicted due to a default judgment. Now, default judgments can be set aside. If the judgment is set aside, then the tenant is given, the judge will set the case for a new trial. Tenant will be given an opportunity to go back to court on a different date and present their defenses. If the default is not set aside, then the landlord can ask the sheriff to evict the tenant from their rental unit, and that can happen as soon as 10 days after that judgment was entered. I'll also note that in order to ask the court to set aside the default judgment, the tenant does need to file a motion asking the court to set aside the default judgment. And that motion needs to include information about, one, why the tenant didn't appear at court. You need to explain whatever happened that resulted in them failing to appear. And two, it needs to state the reasons for why they believe that they shouldn't be evicted, their defense. And then ultimately the court will consider that and make a determination as to whether or not they are willing to set that aside or not. Next slide, please. The next judgment I'm going to talk about is called a consent judgment. And a consent judgment is entered when the parties have agreed to something, have agreed to a settlement. So, for example, a tenant may consent to give up possession, move out by a particular date if the landlord agrees to dismiss their request for damages. Another type of consent judgment I frequently see is a tenant might agree to a payment plan. And provided that the tenant makes all the payments on the agreed upon date, then the landlord may agree to dismiss the case and the tenant won't be evicted. So it's a negotiated settlement. Now, it's essential that the tenant read these consent judgments, that they understand the terms of the consent judgment and agree with those terms before they sign it, because these are final once they're signed by the judge and cannot be set aside. And in the event that the tenant fails to complete one of the terms that they've agreed to, if they default, then the landlord's in a position where they can ask the sheriff's department to evict the tenant from the dwelling. Of course, if the tenant does complete what they've agreed to do, for example, makes all the payments on time, at that point, the landlord should file a satisfaction of judgment with the court, putting the court on notice that the conditions of that settlement agreement have been complied. Next slide, please. Right. Of course, the tenant does have a right to have a trial. Normally, the trial will occur 1 to 2 weeks after the return date. That's my experience in the counties that I practice in. I do think that can vary depending on the county, but tenants do have a right to a trial. It's important that the tenant bring all of their evidence to court on the date of trial. That's going to include things like photographs of perhaps issues in the home that needed to be repaired, videos of those issues, any text messages, emails, copies of letters, of communications with the landlord discussing these issues. Certainly, if it's a rent case and the tenant's paid the rent, they'll want to bring all those receipts. The one thing I will note is there are some courts that do not allow tenants to bring their cell phones into the courthouse. So if a tenant has any information on their cell phone that they're hoping to show the judge, my advice is to contact the court beforehand, find out what that court's policy is with respect to that. If it is a court that does not allow parties to bring in their cell phones, the tenant might be able to get permission from the judge to bring it in for their trial date. If that's not an option, then the tenant really needs to print those things out and be prepared to bring hard copies of those to court. Now, at trial, the landlord's witnesses will testify first, and once the landlord's witnesses have testified, the tenant will have an opportunity to ask their witnesses questions through a process called cross-examination. Once the landlord's presented their case, then the tenant will have the right to testify and offer their evidence, offer to show their evidence to the judge. And the tenant can also have any witnesses that have firsthand relevant information about the case to testify on their behalf. Once the judge has heard all of the evidence, then the judge will make a determination about who wins, who loses. If the tenant loses, then the judge is going to enter a judgment against the tenant for the amount of rent or other charges that the judge has determined that the tenant owes the landlord. The judge will also likely enter a judgment against the tenant for possession, which can result in the tenant being evicted. Next slide, please. So Missouri does give tenants the option to pay all of the rent that the landlord is claiming that the tenant owes and avoid being evicted. So the process is referred to as pay and stay. And essentially, if a tenant is able to pay all of the rent that the landlord is claiming is owed prior to court, then the landlord is no longer able to obtain a judgment against the tenant for possession and is therefore unable to evict the tenant. Now, this right to pay and stay the rent and avoid eviction is also available to tenants after they've had a trial, but the process can be slightly different. Now, if the trial has concluded, then the tenant can file a what's called a trial de novo or a new trial. And they can do so by going to the court clerk's office and asking for an application for a trial de novo. That needs to be filed no later than 10 days after the date of judgment. And in addition to filing that request for a trial de novo, the tenant also must pay the entire amount of the money judgment. And the entire money judgment may include more than just the rent. That may also include fees, costs, really anything else that the judge concluded that the landlord owes the tenant. So that is a process for pay and stay after trial. Although, excuse me, I will note that there are some counties that I work in that have a slightly different procedure. I think that this procedure is generally safe, particularly if the tenant's unrepresented, because it ensures that this issue gets put before a judge. But I will note that in a lot of counties that I work in, if the tenant is able to pay the entire amount of the judgment prior to the date that that judgment becomes final, 10 days later, courts will, again, in my experience, stop the stay the execution of the eviction, stop the eviction, meaning the tenant won't be evicted. And in those counties, there's not the need to file a request for a trial de novo. You know, honestly, if you find yourself in a situation where you want to pay the rent that's due after the trial, I'd say if you can consult with an attorney who's familiar with your jurisdiction, do so. Otherwise, I do think the process that's set out on this slide, requesting the trial de novo within 10 days, paying the entire amount of the judgment that was entered, is the safest way to go. But again, not always necessary. Next slide, please. Okay, so now I'm going to briefly discuss the appeals process in eviction cases. And the appeals process is slightly different for rent and possession cases and unlawful detainer cases, but it is possible to appeal either of them. So a rent and possession case, the appeal process begins with filing a request for a trial de novo, which just means a new trial. Again, those applications can, in my experience, be had or be gotten at the court clerk's office. And those need to be filed no later than 10 calendar days after the date of judgment. Courts will require a small filing fee for those, although tenants can ask the court to waive those filing fees, especially if they're lower income. Now, that initiates the appeal process. However, if a tenant wants to pause the eviction pending the outcome of that appeal, then there's another step. And typically that is what a tenant is going to want to do. So in order to pause the eviction pending the outcome of the appeal, the tenant is going to need to file what's called an appeal bond. And the appeal bond is the entire amount of the money judgment that the court entered against the tenant. It needs to be paid into an account with the court's registry. So if the tenant files the request for the trial de novo, pays the appeal bond in the entire amount of the money judgment that was entered against them, then the eviction will be paused pending the outcome of that trial de novo. Now, tenants can also appeal from an adverse decision in an unlawful detainer case. The process is different. In an unlawful detainer case, there is no right to a trial de novo. So the appeal process begins by filing what's called a notice of appeal. Again, that's a form that the tenant can get from the court clerk's office. Now, the notice of appeal needs to be filed within 40 days of the date of judgment. However, if a tenant wants to pause the eviction pending the outcome of that appeal, then just like in the appeal for the rent and possession, they do need to post an appeal bond in the amount of the money judgment. That money judgment needs to be paid to the court. And even though the notice of appeal can be filed 40 days after the date of judgment, that bond really needs to be posted much sooner than that, because at the end of the unlawful detainer case, the landlord is going to be in a position to potentially execute the eviction against the tenant after 10 days. And so my advice is for tenants to file that notice of appeal along with the request for the bond and the amount of the bond no later than 10 days to ensure that the landlord's not given an opportunity to try to execute on that eviction. Next slide, please. All right, well, that concludes my discussion on the eviction court process, and I'm happy to try to answer any questions that anybody may have at this time.
I guess I'll still show this. There was a question here that I think maybe you might be able to answer, Roger. It deals with in cases where there's been some rent paid, but not all. And when rent is applied or payments are applied to what's paid first, if there's rent and late fees, and let's say the landlord wants to apply everything to the late fees, who determines what is applied or what the payments are applied to, I guess?
The first place I would look to is what the lease agreement says. Sometimes lease agreements state how those payments will be applied, what they'll be applied to first. If the lease agreement is silent on that, I would certainly argue that the money that's been paid by the tenant should be applied to the rent. And if it were to go to trial, I would argue that rent's not owed, and therefore the tenant shouldn't be evicted for unpaid rent. How a court would actually, what a court would actually do with that, it's hard to predict sometimes what particular judges would do, but I would say if the lease agreement spells that out, I think the court's likely to follow the lease agreement. If the lease agreement's silent on that, I think that there's a very good argument that, if the rent's been paid, the rent's been paid, and that what else is owed is fees, and the tenant shouldn't be subject to eviction. But I think that different judges would probably treat that slightly differently.
Yes, and if I could just add, I think that the statute's clear. You can only be evicted for non-payment of rent. So if you just owe fees, late fees, or whatever types of fees, that's something you can be evicted for. And the judgment is required to be itemized and spell out what is for rent, what is for late fees, attorney fees, or court costs. And if it's not itemized, then they can't evict you with that judgment.
Thank you. Alrighty, I know that we only have about 5 minutes left.
All right, so anyway, I'm sorry we're not getting to all the questions or whatever. Our next speaker is Marissa Cohen, and she is going to be presenting on fair housing. And she is with the Metropolitan St. Louis Equal Housing Opportunity Council, or EHOC. Thank you, Marissa.
Thank you so much for that, John. Good afternoon. My name is Marissa Cohen, as John mentioned. I just want to give a brief overview of who EHOC is. We are a private nonprofit fair housing organization that assists people who believe that they have been victims of housing discrimination. And while we're talking about evictions today, I will say that we find a lot of callers that contact us are having issues with their landlords, and we are able to uncover some more deeply rooted discrimination issues. And so in some cases, this may be applicable. It's EHOC's mission to work to ensure equal access to housing for all people through education, counseling, investigation, and enforcement. We operate throughout the metropolitan region. So while we are located in St. Louis, we also work in parts of Missouri as well, all across Missouri, as well as parts of Illinois. To give a brief overview of the Fair Housing Act. The Fair Housing Act was passed in 1968, and it prohibits discrimination against protected classes during housing and housing-related activities. So this is a little different than Missouri landlord-tenant law. It is separate from Missouri landlord-tenant law, which is what we have been talking about during this presentation. And I would like to outline some of those differences. So when it comes to enforcing your fair housing rights, you must know that it has to be an issue of discrimination against protected classes. So who are the protected classes? This includes race, color, national origin, religion, gender, disability, and familial status. So if, for instance, you are being treated differently in your housing or being denied housing on the basis of any of these identities, then you are able to assert a fair housing complaint. One of the things that I would like to mention is that gender is inclusive of sexual orientation and gender identity and expression. This was passed back in 2021 under the Biden administration. And so that is additional protections across the board for all people. These are federally protected classes. So regardless of what city, county you may live in, these protections still apply. Also, for familial status, this is in reference to families with children in their household 18 years or under. This also is inclusive of pregnant mothers, as well as families that are attempting to gain custody of a child 18 years or under. And for those that have a disability, I would like to mention that you also, under the Fair Housing Right, you have the right to request what are called reasonable accommodations or reasonable modifications. So reasonable accommodations can be changes to the lease or the terms of your, to the terms of your lease. And that will be able to assist you in being able to enjoy your dwelling or meet the requirements that you may need to meet for your housing. Reasonable modifications allow you to make physical construction changes, typically at the tenant's expense, unless you live in public or subsidized housing, but you can make physical changes, such as installing a ramp or grab bars, those sort of things, to your property if that is needed for your disability. So when we talk about the housing-related protections, the Fair Housing Act prohibits discrimination against protected classes during housing and housing-related protections activities. And so this includes renting, but it also includes those that are looking to buy or sell a home, obtaining refinancing a mortgage, obtaining homeowners insurance, occupancy permits, or dealing with zoning or occupancy issues, and even viewing real estate advertisements. So statements such as "no children allowed" are discriminatory or blatantly discriminatory statements as it relates to real estate, and that would fall under that familial status protection. This also applies to temporary or long-term shelters any entity whose actions can make housing unavailable, organizations that are offering rental assistance, vouchers or subsidies, housing counseling and placement programs, clean and sober housing, transitional housing, as well as motels that are functioning as primary housing rather than vacation lodging. Some of the prohibited acts that EHOC investigates, or that the Fair Housing Act lists, right? It doesn't give a list of who can be sued, but it tells us what's prohibited under the Fair Housing Act. So a blanket denial of availability, saying that, you know, housing is unavailable simply because of a person's national origin, right? Providing a difference in terms or conditions of the lease, for instance, requiring all families with children to live on the first floor, restricting choice, right? So maybe only allowing certain individuals to live in one area, and that is based on one of their protected class, whether that's their race or their family status or even their disability status, any of those protected classes. Discriminatory advertising, providing false information, blockbusting, and also a refusal to make reasonable accommodations or modifications, which is a right for individuals with disabilities. Oftentimes, it is very difficult to detect when housing discrimination is occurring. So we encourage you to contact EHOC and let us know if you are suspecting, if you feel that there is potentially housing discrimination happening. Oftentimes, it's more subtle than it is blatant. And so again, as Susie recommended at the beginning, documentation is key. Even as it relates to asserting your fair housing rights, it is very important that you document your experiences, document phone calls, text messages, things that are being stated, even policies that are being recorded that could be discriminatory. Oftentimes what we see today is discrimination is a bit more subtle and less obvious, so it may be difficult for one person to detect that. When we receive complaints about fair housing issues or possible discrimination, EHOC will then file those complaints with HUD. We no longer file those complaints with the Missouri Commission for Human Rights because the state of Missouri is actually out of compliance with the federal Fair Housing Act, which there is a lot of work that is being done currently within EHOC and other organizations across the state that are interested in advocating for Missouri to regain compliance with the Fair Housing Act. If you're interested in that, we would love to talk to you about that work. Also, some of our enforcement may include some conciliations or settlement agreements between both parties. Private lawsuits are also another form of enforcement. When making complaints, you have within 1 year of that incident, of the last discriminatory incident, to file a complaint with HUD. And for private lawsuits, you have within 2 years to file that complaint. In all cases of fair housing discrimination, retaliation is protected. So I will leave our contact information here. You can access our services via our phone number, which is 314-534-5800, or you can also submit a complaint online at our website, www.ehocstl.org. Currently, our hotline is closed, but it will reopen on Monday. And so you can keep that in mind. And this is also our address. Thank you so much.
Thank you, Marissa. Looks like there's a few questions in the Q&A about specifically about your presentation. One is, what is blockbusting? I think somebody wasn't sure about that.
Yeah, so blockbusting is the practice where people were approached to, say, sell their homes, right? Back before 1968, when the Fair Housing Act was passed, they would be approached to, say, sell their homes because the neighborhood is changing. And it was fueled by racist sort of ideologies saying, you know, the demographics are changing in the area and you'll want to sell your home and get out, right? And so there was just this practice of clearing out areas, which also led to gentrification a bit later.
And I guess there's a question too about what EHOC assists with, subsidized Section 8 housing? I don't know.
Yeah,
see that?
so we are not a housing provider. So we do not provide housing in that sense, but folks who have Section 8 housing or subsidized housing can contact us if they feel that they are being discriminated against, regardless of the type of housing that you live in. So I hope that answers your question.
Okay. I don't know if it's in the scope of your presentation, but there's a question about not allowing military members to rent in specific places. I don't know if that falls within fair housing or not.
So military status is not a protected class in Missouri. But there may be other laws that apply that can support you in accessing housing if there's an issue or a barrier. In Illinois, there are some protections for folks who are active military members. And then I do see the question about Missouri being out of compliance. I will put my email address, my personal email address for those who are interested in learning more about that work. It is something that is starting from our office, but we're working in conjunction with Empower Missouri, which is also a statewide campaign. And we do service individuals across Missouri as well as in parts of Illinois.
I think that brings us to the end of our presentation. I would just like to, I guess if you could go to the next slide, Christina. So this is the slide that, as far as how to find the legal services or legal aid in your area. So there's a website, www.lsmo.org. And if you go to that website, you will be able to find the different, and it's Legal Services of Eastern Missouri, Mid-Missouri Legal Services of Southern Missouri, and Legal Aid of Western Missouri. And those are the four organizations. And one of those organizations covers the county that you live in. And then I will also add that coming soon, there's going to be a website to help you, I guess, defend an eviction lawsuit on your own, and maybe that would help you file responses and make sure different things like that. So that's going to be coming soon. I just wanted to let everybody know about that. And we'll be disseminating information about that. And this is going to be available as a recording, and there were a lot of questions about slides. The slides are going to be available, can be sent out. And I'm sorry we couldn't get to everybody's questions. It just, if your question wasn't answered, please contact the legal services in your area, and hopefully somebody can help you. And that's all I have. Thank you.